everyone. I welcome you all to today's Focus of the Day session. Today we are going to talk about the PMLA amendment which has been upheld by the Supreme Court. We are going to cover this topic in the following sequence. First of all, why it is in news, then the court's verdict, the provisions that have been upheld, followed by the prelims and means-based practice question for you all. But before that, I want you all to be informed about the Mains 8 2022 program by Analyst IAS, wherein you can get help for polity, essay, public administration and ethics. Do check out the details given over here and apply soon to improve your scores in the upcoming mains examination and also to avail the early bird discount. Moving back to the topic, why it is in news. So the Supreme Court has upheld powers of arrest, raids, seizure under PMLA. What is PMLA? Before we get to that, I want you all to take a note of the Supreme Court verdict. The Supreme Court has upheld the amendments made to PMLA Act. These amendments give ED, that is Enforcement Department, wider powers of arrest, seizure and makes it difficult to obtain bail. So these are the provisions that have been upheld. An upshot of judgment by Supreme Court on the validity of certain provisions under the Prevention of Money Laundering Act. So I hope your question, what is PMLA, has been answered. It's Prevention of Money Laundering Act. The offense of money laundering is as heinous an offense as terrorism. Section 3, defining money laundering. Section 24, reverse burden of proof. And Section 5, attachment of property to stay. Stringency in granting bail under the Act is legal and not arbitrary. It is not mandatory to give an enforcement case information report ECIR in every case as it was not an FIR. The statements made to ED are considered admissible. Provisions of attachment of property of accused as proceeds of crime balances the interests of accused and the state. The question of enactment of PMLA amendments through the money bill route is to be decided by a larger bench. So there is one aspect of the whole case which is yet to be decided by a larger bench, that is whether passage of PMLA Act through money bill was fine or not. ED's power of arrest. The petitioners had argued that ED could arrest a person even without informing him of the charges. This power was violative of right to due process enshrined in Article 21 of the Constitution. However, the court rejected the notion that ED has been given blanket powers of arrest, search of person and property and seizure. The court said there were inbuilt safeguards within the Act, including the recording of reasons in writing while effecting the arrest. On not providing ECIR to the accused, Supreme Court held that it was not mandatory for the ED to provide a copy of the Enforcement Case Information Report ECIR to the accused. The court was of the view that it is enough if the ED disclosed the grounds of arrest at the time of arrest. ECIR is an ED document which is widely seen as similar to the Police First Information Report FIR. Twin conditions of bail. The court upheld the stringent twin bail conditions required under the law for granting bail to an accused. The two conditions require a court to hear the public prosecutor against the bill plea and reach a satisfaction that there are reasonable grounds to believe that the accused is not guilty of the offense and that he is not likely to commit any offense while on bail. However, the court said under trials could seek bail under Section 436A of the Code of Criminal Procedure if they had already spent one half of the term of punishment in jail for the offense prescribed in law. But again, this is not an absolute right and would depend from case to case. Issue of the burden of proof rests heavily on the shoulders of the accused. The court upheld this provision and said that this provision did not suffer from the vice or arbitrariness or unreasonableness. Introduction of the amendments through money bills, the Supreme Court held that this issue would be separately examined by a larger bench of the apex court. Now let's look at the prelims based practice question. With reference to the Prohibition of Benami Property Transactions Act 1988, PBPT Act, consider the following statements. A property transaction is not treated as Benami transaction if the owner of the property is not aware of the transaction. Number 2, properties held Benami are liable for confiscation by the government. Number 3, the Act provides for 3 authorities of investigations but does not provide any appellate mechanism. Now these 3 are your statements and you have to pick the answer from the given combinations. A, 1 only, B, 2 only, C, 1 and 3 only, and D, 2 and 3 only. Pick the correct alphabet and put in your answer in the comment box. The main practice question for today is, how has ED become the weapon of choice today? Discuss. You have to answer this particular question in 250 words. This is it for today. I shall see you again tomorrow with another focus of the day session. Till then, take care, stay tuned. Thank you so much for joining.